trail of both Jubilee and NASA principals who are campaigning today as well. So we'll be telling you a little bit more about that. We have our reporters on the ground keeping an eye on that. So like I mentioned, apart from the ballot printing case, we're also following the campaigns by the two main presidential candidates, Uhuru Kenyatta of Jubilee and Raila Odinga of the National Super Alliance. Raila will be in Kitui after 2 days in Narok, while Uhuru goes to Kitui after an extensive tour of the Mount Kenya region. We will also be uncovering the collective bargaining agreement signed between the national government and the Kenya Medical Practitioners and Dentists Union. The deal was signed this morning. I'm Linda Gutu. Welcome to the program. Let's begin from the corridors of justice. A three-judge bench of the High Court this morning starts hearing the case by the opposition alliance, NASA and the Third Way Alliance, challenging the award of the ballot paper printing tender to Dubai-based Al Ghurair printing firm. Let's cross over to Milimani and listen in a little bit to what's happening at the moment.
Compliance. This article requires compliance. We cannot run away from compliance. As what the respondent has done, and looking at the circumstances of the case and the history of this constitution, and in order to protect the sovereignty of the people, can it be said that in these circumstances and with all the shenanigans, that the respondent can deliver an election in terms of Article 88 or 81 of the Constitution? My Lord, the answer is that it is most unlikely. Most unlikely. And they know it. In fact, reading the affidavit of Chiloba, it is all about unpreparedness, all about indecision, all about timelines which have not been met. And it ends up with Article 86, that at the end of the day, whatever method you use, it must be simple, accurate, verifiable, secure, accountable, and transparent. The way we're dealing with Al Ghurair at this particular point in time, I'm not sure, Your Lordship, that we can be able to meet these constitutional standards. And we should ask accurate, verifiable, accountable, and transparent to who? It is to the people, not to the commission. It is to the people. Mr. White.
You actually took your 30 minutes.
No. I thought...
29 and a half minutes.
Oh, my Lord. I was looking at your hand and thought of this.
Yes.
Sorry.
So Mr. Awelo will have 15.5 minutes maximum.
With another little 4.
Yes. Now, so just before, as you start, maybe you can answer this for the applicant. The orders sought are to quash the decision of the respondent with respect to the award of the tender for the printing of the election materials for the presidential elections or all elections to be held on August 8th.
My Lord, that should be all elections.
Lord, for my part, I'm sorry to interject. When I raise my objections,
My Lord, I'll explain. I think
no, allow me. At the point of leave, I made it very clear that I was objecting to the grant of leave, and I even mentioned in my submissions before His Lordship, the Honorable Justice Odunga, you cannot dissect a presidential election from the other election. And my words, to be precise, were tomorrow we will see a ward representative coming to this court saying they want Al Ghurair not to print the ward elections. So they did not, at that stage, inform us, at least my client. We would like to limit ourselves merely to the presidential election or broaden it to include all the elections. And lastly, when they served me with their notice of motion, I was very adept to check, and I confirmed they have stuck to the original position for which they were granted leave. Therefore, at this stage,
Which is?
presidential, they have limited themselves. I have the document here with me. Paragraph number A, it's presidential. It does not reference all elections. My thrust of submissions is based on that.
My Lord, I wish you would have been allowed to explain. Mr. Kinyanjui has this habit of just shooting up. I mean, you should have let Mr. Wele finish.
All right.
Yeah, I mean, and when my learned friend was trying to explain,
Yes.
then he says, no.
It's-
I mean, that is not how we conduct ourselves in court.
It's okay, Mr. Orengo. It's fine. I've taken note of that. It's one of the issues I think that will be conversed here. So, Mr. Wele, it's one of the questions you should respond to as you
Yes, and my Lord,
start your 15 minutes.
yes, and that is a question I think that can best be answered by the nature of the case that we bring before the court. My Lord, this case is about impressions and perceptions. It is about a critical process in the enforcement of the right to self-determination, and which I believe my learned senior has already extensively submitted on. But the more important point, my Lord, that we would like to make, particularly with regard to that particular question, is that we are concerned about the credibility of the election because of certain actions by the respondent and a candidate in these elections for the office of the President of the Republic of Kenya. And not by the actions and or conduct of other participants in the entire electoral process. So the focus here is, inter alia, the associations between one of the candidates, the presidential candidates, with a firm that has been awarded the contract to supply a very critical component for the elections. And so, my Lord, based on the submissions that we shall make, I believe that it is within the jurisdiction of the court, bearing in mind the evidence that we shall provide, to come up with a determination that will best serve the interests of justice. And if that means cancelling the tender, specifically with respect to the printing of ballot papers for the presidential elections, so be it. If that is what will better serve the interests of justice. My Lord, as my learned senior has already submitted, the legitimacy of an election can only be as strong as the process leading up to those elections. And my Lord, as I've already also alluded to, one of the most critical components of the electoral process is the printing of ballot papers. And I'll urge your lordships to take the examples of past elections in this country, just to illustrate the importance and the significance of ballot printing in an electoral process. In the supplementary affidavit of Mr. Norman Magaya, my Lord, we have annexed reports by election observer groups in the 2007 and 2013 elections. The Commonwealth Election Observer Report and the Carter Center report on the 2013 elections, where it is very clear that the procurement process leading up to the printing of ballot papers and the printing of the ballot papers themselves are very important considerations in determining public trust in the elections. And so, my Lord, under Article 38(2) of the Constitution, every citizen, every one of us has a right not just to regular elections, but to free and fair elections. So that any citizen, be it 1 or 2 or 10 or a million, who have any reason to believe that that constitutional right is likely to be contravened by a component in the electoral process, they have a right to rush to court and to seek the protection of their constitutional right. And the reason I say so, my Lord, is the printing of ballot papers has a direct correlation with ballot stuffing as an electoral malpractice. And so, my Lord, when the applicant says that it is apprehensive that a firm that has associations with one of the presidential candidates has been awarded the tender to print ballot papers, that concern must be taken very seriously. And my Lord, the reason why that apprehension arises is as follows. My Lord, the tendering process for these ballot papers started on the 17th of August 2016. It was through an open international tender. My Lords, that tender was awarded to the first interested party, Al Ghurair, Printing and Publishing, LLC. My Lord, that award was challenged before the High Court. And it was quashed. And why was it quashed, my Lords? It was quashed because a person or an officer of the respondent who had no authority in law and who knew he had no such authority in law to sign contracts or to enter into contracts or to bind the commission in contracts, purported to hurriedly sign the contract between the commission and the first interested party. My Lord, he knew that the law had changed. Bringing in new commissioners for the first respondent, for the respondent. And even if he was ignorant of that change, my Lord, that cannot be a defense. The fact is, he hurriedly signed a contract with the hope that his actions would be shielded by Section 167 4C of the Procurement Act, which basically is to the effect that once a contract is signed, it cannot be challenged. That was the motive behind that hurried contracting. And my Lord, the Honorable Justice Odunga quashed their word on that basis. Now, my Lord, the first interested party appealed to the Court of Appeal, and that decision, the decision of the Honorable Odunga, Justice Odunga, was upheld on the same grounds. That it was evident that this particular accounting officer was trying to rush the signing of this particular contract for reasons other than those provided for in the law. My Lord, this, after losing at the Court of Appeal, this particular tender is yet again subjected to restricted tendering. My Lord, the tender is yet again.
Just a friendly reminder, you
Yes.
have 5 minutes left.
My Lord, I will try my best to hurry up. My Lord, yet again, the Commission invites a few bidders to tender for the ballot papers. And yet again, who is awarded the contract? The first interested party. If you look at the decision of the PPRB, which we have annexed in our supplementary list of documents, you will see that the PPRB basically says, in basic terms, it says that you, the Independent Electoral and Boundaries Commission, favored, and unfairly so, favored the first interested party. The evaluation criteria was not objective at all. This was a tender that ought to have been published to the entire world for bidding, but was only restricted to a few individuals. Mind you, my Lord, the few other individuals, other than the first interested party, who were invited to bid, are the same bidders who had been found to have not met the preliminary requirements of the first international tender, and were neither financially or technically responsive in their bids. In other words, what the PPARB was saying was that you invited people who were in any event, in your view, already unqualified for this particular tender. And, my Lord, our submission is that that was done in order to lock out competition. It was done in order to lock out competition. That decision was again quashed, my Lord. And this time round, what does the Commission decide to do? It decides to go for direct tendering. In direct tendering, my Lord, yet again, who is selected? The first interested party is yet again the preferred firm for this task. As my learned senior submitted, my Lord, you will see that in the media briefing, and this is the first time that the public gets to know about the award of this particular tender. In the media briefing, you see that the activities leading up to the selection of the first interested party are the elimination of certain firms. One of them is Alarms. Alarms is a local printing company. And in the view of the Commission, the perceptions of the political class would not allow them to award the tender to Alarms. As a matter of fact, my lord, the same view is held with respect to Al Ghurair. In the same media briefing, they say that because of the litigation that has been going on in the tendering process, the perceptions of the public with respect to the first interested party are becoming very negative. All right? So already, the integrity and transparency of the process is, with the admission of the Commission, in question. It's already in question by the time that they are making these considerations to award the tender directly. But they go ahead and award the tender anyway to the first interested party. Now, my lord, they had all the right under the law to go for direct tendering, but only if they meet the threshold that has been set out under the relevant provisions of the Procurement Act and the Constitution. And in that regard, my lord, we refer and rely on Article 10 of the Constitution and Article 227(1) of the Constitution and at Section 3 of the Public Procurement and Asset Disposal Act on the principles that are to be considered in every procurement by a state organ. My lord, if you look at Section 103, a state organ or a public entity can only resort to direct tendering where, and we have to place emphasis on this, where the intention is not to avoid competition. We have demonstrated that all along the intention was to eliminate other contenders, to unduly favor the first interested party. But more so, of course, the tendering has to be, again, based on one of the provisions enumerated under Section 103(2). Now, in the media briefing, as my learned senior has already submitted, the reasons given for direct tendering were under 103(2)(a).
Mr. Roy, the time is up.
My lord, allow me to just finish this particular point and I'll be done.
That sentence you mean, right?
Thank you.
Okay.
Sorry?
That sentence. Could be a long sentence.
Thank you, my lord. Thank you. My lord, under Section 103(2)(b), which they now say they awarded the contract under, you can only award a contract under that particular section where the circumstances enumerated thereunder were not caused by your conduct. We have already demonstrated that the conduct of the Commission throughout, from 17th of August 2016, was all calculated at awarding this tender to the first interested party. And mark you, my lord, all this time, whenever they are taken to court, the one argument that the Commission always advanced is that in the interest of time and in the public interest, it is necessary that we proceed with this tender without further interference.
Okay, thank you. Now,
So,
time is up.
yes,
But
so
you need to answer a question for us before you say.
very well, my lord.
So, in your view, the likely consequence of being granted the orders you seek will be to interfere with the timelines for elections. Do you concede that?
Not at all, my lord.
Not at all.
Not at all.
Good.
Not at all. In fact, my lord, in the supplementary affidavit of Mr. Norman Magaya,
Yes.
the deponent gives reasons why
Yes.
it is not prejudicial. The orders we are seeking are not prejudicial to the 8th of August general elections. As you will note, my lord, the printing of ballot papers for the presidential elections by the admission of the commission starts on the 18th of July. 18th of July. That is just about 3 weeks to the election. It means that this can be done. It is possible to be done. And if, my lord, we are going to go to the general election just for the sake of it, when the commission has already admitted that it is possible to print these ballot papers 3 weeks to the election, and by some of the statements that it has made, clearly also generously allocated more than a time that is more than is necessary for certain activities. For instance, flying of ballot papers from wherever they'll be printed to Kenya. They have granted 7 full days for the flying of ballot papers to the country. Really, you can see that there's just so much time that can be used to evaluate whether it is actually necessary to retender or not. My lord, I have,
You have
left
answered
out
the
so
question.
much of what I really needed
I am
to
sure
say.
it's in your written submissions.
Yes, and I really would probably, my lord, beg even for just 3 minutes to finish. Just 3 minutes.
Okay.
Thank you, my lord.
Justice Mativo has
Thank you.
taken mercy upon you.
Thank you.
Yes.
So, my lord, what we are saying is that the Constitution is supreme, and my lord, it fronts for transparency and integrity as paramount principles in consideration by public institutions in their decision-making processes. The Procurement Act may very well front for costs, effectiveness of the procurement process. But where there's a conflict between the two, and we believe there is none, transparency and integrity must be paramount. What the Commission did, my lord, was to elevate cost effectiveness above transparency and integrity. Because the Commission has always known the concerns of the applicant with respect to the first interested party. It alluded to the same in the media briefing. But it went ahead to award the contract anyway. And my lord, had the Commission engaged all the stakeholders before making this decision, it would not have made that decision. And even if it did as it claims it did, it has always been a very clear message from the applicant's principles that, my lord, the first interested party does not inspire any confidence whatsoever in the minds of the applicant and its followers. Surprisingly, my lord, I have seen the submissions of the Commission, and one of the issues, the defenses they give, is that under Section 44 of the Procurement Act, the procurement process is supposed to be confidential. My lord, that is a misapprehension of the law. Confidentiality in a procurement process is usually aimed at protecting the financial information, the commercial information of different bidders, in order to spur competitiveness and the integrity of the procurement process. It cannot be for the purpose of running away from responsibilities of accountability and transparency, as was done in this case. And in any event, my lord, this was direct procurement. What was so special about hiding the decision that was to be made regarding the first interested party? My lord, we have attached authority on that particular point, and my lord, it is not in our list of authorities, it is in our supplementary bundle of authorities. It is the authority of Republic versus Public-Private Partnerships Petitions Committee and 3 others ex parte APM terminals, the 2015 EKLR. So in sum, my lord, what we are saying is that the decision by the respondent was clearly a predetermined one. It was meant for a predetermined outcome and was clearly meant to favor the first interested party. The same cannot stand, my lord, in view of the provisions of Article 227(1) of the Constitution and Article 10. And my lord, our emphasis is on transparency and integrity of the process. It permeates every aspect of the decision-making process of the respondent. And if any decision during the process leading up to election does not meet those particular requirements, it does not matter that the tender award is cost-effective or competitive. It must be quashed. And so, my lord, with those very many words, I would, unless you have any questions for me, I'll hopefully make my other points in rebuttal in response to my learned friends.
Thank you, Mr. Awele. I know this is one of the rare occurrences where you hope we have questions, but we don't. Mr. Karori, you're next.
Yes, my lord, I'm just seeking your direction before we start.
Yes, please.
There is an interested party that supports the applicant. Yeah. And obviously,
Oh, there is. And who is that?
Myself, my lords.
Okay.
I am for the fourth interested party.
I see. So you will go next.
Yes.
Yes.
My name is
Mr.
Mutuma.
Yes.
For the fourth interested party. That is Dr. Ikuru of Court and Third Way Alliance, Kenya. For the record, we are partially in support of the notice of motion. In as far as it seeks prohibition to restrain the first respondent from considering and awarding the tender for the printing of the presidential ballot paper only to the first interested party. My lord, my client is a presidential candidate in the forthcoming elections. He's therefore here to protect his interest as a candidate. Those of his party, Third Way Alliance Kenya, and the voters at large. My lord, the respondent is a public body charged with the responsibility of conducting elections and referenda by dint of Article 88 of the Constitution. Therefore, its actions are open to scrutiny when there is breach of the law. My lords, under Article 47, Sub-Article 1 of our Constitution, every person has a right to administrative action that is expeditious, efficient, lawful, and procedurally fair. Our grievance is that the respondent has breached that duty of being procedurally fair in the awarding of this tender to the first interested party. To give effect to Article 47, Parliament was charged with the responsibility of enacting legislation, which it did in the name of the Fair Administration Action Act of 2015, which I shall refer to at the tail end of my submissions. My lords, under Article 86, the IEBC has a constitutional and administrative duty to ensure that whatever voting method used, the system should be simple, should be accurate, verifiable, secure, accountable, and transparent. D, the IEBC has a duty to ensure appropriate structures and mechanisms to eliminate electoral malpractices are put in place, including safekeeping of election materials. Our submissions, my lords, is that IEBC is likely to breach this duty by awarding the tender to a firm that has associations with one of the political players in this election, because it cannot ensure safekeeping of electoral materials. My lord, my client has sworn an affidavit which is filed on 27th June 2017. It was sworn on the 26th. He has adduced evidence indicating that one of the presidential candidates in this election has had more than one interaction with the printing firm. I urge your lordships, when you try to do your judgment, refer to our exhibits number EA 2 and 3 and EA 4, indicating those kind of interactions. My lords, we submit that there has been outright bias on the part of IEBC in awarding this tender, and I would like to refer your lordships to paragraph 22 of the replying affidavit sworn by Ezra Chiloba, who is the CEO of the respondent. He admits in this paragraph that prior to the awarding of this tender, he actually met two representatives, one Honorable Raila Amolo Odinga and Honorable Wetangula, and Mr. Raphael Tuju, to discuss the possibilities of awarding this tender to Al Ghurair. Now, my client is a presidential candidate, my lords, he was not consulted when these two were consulted. My client has equal and overwhelming chances of becoming our next president and the commander-in-chief of the armed forces. Therefore, inviting only two parties to discuss the awarding of the tender is outright bias. On that ground alone, this tender has to be set aside. My lords, having in